SJC-11530, Emery G. Snell Jr. v. Office of the Medical Examiner.
Mr. Snell, good morning. We apologize for the difficulties on Tuesday. So you may proceed, sir. You have 10 minutes.
Good morning, Mr. Chief Justice and Associate Justices. Today I'm here to argue a public records request that for the last 6 years has been denied me. The issue before the court is one of grave importance as it represents the public interest at large. In 2013, specifically March the 8th, Sean Williams, the supervisor of public records, granted an administrative order on my request of 27 paragraphs for information before the Office of the Chief Medical Examiner. The Chief Medical Examiner's General Counsel refused the request, and I petitioned the SPR for appeal of that denial. Upon that completion of the appeal, the SPR granted my public records request, ordering that the OCME respond within 10 days. As the court may note, that March 8, 2013 administrative order not only contains a finding of fact, but it also contains case law, which this court and courts of the Commonwealth have maintained in regards to the public's right to know and the transparency of government. The OCME refused the 10-day order, and as per law in 2013, I petitioned the Supreme Judicial Court, specifically the single justice, in June of 2013. The single justice, taking my mandamus petition as pretty much the wrong avenue in which to seek relief, denied the enforcement of the administrative order, and I believe the single justice may have been mistaken in the denial because it changed the context of the administrative order to a plain letter. As this court knows, the administrator for the supervisor of public records, pursuant to Chapter 66, Section 1, has the legislative power to promulgate regulations for the operation of the Massachusetts Public Records Law. The SPR, using his power, decided that indeed I was entitled to the records, even though the exception under C of Chapter 4, Section 7, subsection 26, the personnel exemption was issued, responded to, and he found that I was still entitled to the records. It was to my satisfaction that this court decided to take the direct appeal and address this public record issue. Now, the Attorney General representing the OCME, which I believe is a conflict, has stated before this court most recently on February the 28th that indeed this case was moot because Judge Fishman in the Barnstable Superior Court, specifically tomorrow, has ruled that the OCME and the Barnstable District Attorney will bring all the records concerning William Zane, his personnel files included, to the court's attention with flags stating which they think should not be disclosed to the public. This court should note that in my 27-paragraph request, I am not looking for any intimate information on Dr. Zane. I don't want his social security. I don't want his phone number, his address, or any other information I consider is irrelevant. In 1987, Dr. Zane was discharged from the Fellowship of the Chief Medical Examiners in Maryland because he was unfit as a pathologist. In 2011, I newly discovered by former OCME Chief of Staff, Stanton Kessler, that he had mandated certain procedures for Zane, specifically to the autopsy in my case, which was a suspected close contact homicide. Those mandates were that Zane would be supervised on all these autopsies, and he would bring everything concerning those close contact autopsies to the state-of-the-art OCME Boston facility where high-resolution photography can be used, trace evidence can be taken, and the autopsy can be done in a state-of-the-art fashion. Zane disregarded all these mandates. He did the autopsy in Pocasset at the Barnstable State Hospital, and 5 pathologists that I have retained over the last 20 years have all stated that there was no diagnosis of exclusion, there was no asphyxia due to smothering, but in fact it was a natural fatal cardiac arrhythmia. In this case, before the court, I am seeking that information, and Stanton Kessler and Brockton defense attorney Joseph Krosky provided me by affidavit in 2017 those relevant medical issues that were policies that were in place at 1995, and any disciplines that Zane received from the Office of the Chief Medical Examiner, whether it was the chief himself or the chief of staff, Dr. Stanton Kessler. It's my belief that the public's interest is at large here because any information that is released in Barnstable is going to be probably protected under protective order and heavily redacted. So we will end up with another Annie Dukin-esque type of case where the public is not going to learn anything of value as far as the integrity of its employees and whether the law-abiding work performed by them is indeed honest services. Today, I'm hoping that the court will take my position, deny the moot application by the Attorney General's office because this issue is capable of repetition yet evading review, and if it does continue, the Office of the Chief Medical Examiner will continue to destroy records without prior authorization from the State Retentions Act, which is governed by the SPR of the Commonwealth. Before the court, I believe that if this decision is made in the affirmative, that the Office of the OCME's transparency will be made public for everyone to see. And as the media has recorded on Dr. Zane since 1987, up until almost his retirement in 2015, he has proved to be incompetent and incapable of providing autopsies in which the public interest demands of all its employees, specifically the Office of the Chief Medical Examiner. I believe that the court will find that the issue is of such importance to the public that transparency of government will be had by the release of all the records, deleting, of course, all the intimate details, as I mentioned earlier, date of birth, phone numbers, home addresses, whatever. All I'm looking for is to back up the information that I've gained, newly discovered in 2011 from Stanton Kessler and in 2017 from Brockton defense attorney Joseph Krosky, in which both were intimately familiar with the former chief medical examiner for the state of Maryland, Dr. John Smilik. In that regard, Dr. Smilik is dead, Dr. Kessler is dead, everybody that has intimate knowledge of this case is dead. The state of Maryland, I'm hoping with a favorable resolution from this court, I will be able to use that to access Zane's personal records during the fellowship, because during the grand jury of April of 1995, Zane misstated, whether purposely or inadvertently, his employment record after his fellowship, and I believe that my motion under Odell should have been allowed, but this information was hidden from me, even though my defense attorney, through specific Brady to Sari styled scientific motions and 3 motions to compel, was denied this information. It was also denied me when I wrote to the office, of the district attorney for Barnstable County in 1998, prior to my direct appeal being affirmed by this court, that all the records of discovery had been turned over to my trial attorney and my appellate attorney. This has been a complex, convoluted case since 1995. I went from a grand jury indictment to a murder conviction in the first degree without possibility of parole in 125 days. Fair to say, no one in the Commonwealth has ever been convicted in 125 days, not even the Salem witches and not even Sacco and Vanzetti. This information made public will make the Office of the Chief Medical Examiner become more efficient in their duties, specifically now that the new medical examiner's chief has decided to do autopsies light, which basically means unless it's a real need to do an autopsy, they're basically going to look at the body and say, okay, he died of natural causes, he died of a gunshot wound, he died of a stab wound, and if the blood tests come back that they died from a drug overdose, so be it. That's my understanding. It's been produced by articles.
Okay, thank you, sir. Mr. Marks?
Thank you, Your Honor.
Mr. Marks? Mr. Snell says, Mr. Snell raises the issue that the matter is before Judge Fishman, I gather on a motion for new trial, is that correct?
Yes, the plaintiff in his murder case has been pursuing a motion for new trial and discovery in support of that motion for new trial for several years. Most recently, within the last 3 weeks, Judge Fishman ordered the OCME to disclose at least all of the materials that he's seeking in his public records request for in-camera review by the Superior Court, and then for determination of whether to release the records in criminal discovery in support of the motion for new trial to Mr. Snell and his attorneys. So that really just happened, and that process is ongoing.
Right, but it doesn't explain why, if from 2013, when there's a letter saying it's not protected under the public records request, why it has not been furnished.
Well, let's be precise about what the supervisor said. On March 8th, 2013, the supervisor instructed the Office of the Chief Medical Examiner to review its records, to determine what can be released in light of what the supervisor told the Office of the Chief Medical Examiner about how the personnel record exemption is interpreted, and told the OCME to redact if necessary, make an index, and if the OCME decided that records should continue not to be turned over under exemption, under the personnel records exemption, to put that in the index. And the precise order of the supervisor is in the second to last paragraph of his March 8th, 2013 letter. Now, it is true that the OCME did not immediately respond to that. In fact, didn't respond for several months. In the meantime, Mr. Snell brought his action in, but to be precise, the supervisor did not determine that any of the records he sought were public records and were not subject to the exemption, and did not order the production of any of the records. This is part of an iterative process that the supervisor went through. I also have to say,
It should not take 6 years.
well, I'm not there yet, Your Honor, because it didn't. This all happened in 2013. The state of the public records law is significantly different because in 2017, there were major amendments to the law and major changes to the supervisor's, the Secretary of State's regulations. What happened in 2013 is that Mr. Snell filed his action for mandamus relief and asking the OCME to be held in contempt for ignoring the supervisor's order. The single justice dismissed the case because mandamus is an extraordinary remedy. There was no clear, unambiguous command, no clear-cut legal duty. There were alternative remedies, and that's part of the analysis under mandamus. So in June of 2013, the single justice dismissed the complaint. In July of 2013, and this is part of my motion to dismiss the appeal as moot, the OCME sent Mr. Snell's attorney a letter responsive to the supervisor's March letter. The OCME listed all the records, released some portion of the records, categorized the records, made the index that the supervisor said, listed all the records, released what seemed to fit within the public records law, did not qualify as an exemption for the personnel records, and then said, these records are exempt under the personnel records exemption. So the point is that Mr. Snell has gotten the relief he requested of the single justice. Comply with the supervisor's order. July 2nd, roughly, 2013, the supervisor complied with the supervisor's order. So there is nothing left in this case for either this court or the single justice to grant him that he has not already gotten. So the case became moot, Your Honor, in July of 2013. Since then, there has been no further, that I'm aware of, there has been no further interaction between Mr. Snell, the supervisor, or the OCME regarding following up on that index, further discussing whether the specific things that the OCME has said continue to be exempt really are. There's a continuing process he could go through with the supervisor and with the OCME, but it stopped there. So that's why I say the case is moot.
But we still have, I mean, I gather what you're saying is that he was pursuing the public records avenue.
Yes.
That was exhausted, and now he's pursuing a separate and distinct avenue, which is discovery as part of a motion for new trial.
Well, I believe he was probably doing the same thing at the same time. It's just that the criminal discovery avenue did take several years, but he certainly on the threshold of getting those records through the criminal discovery process. The public records process, from my point of view, ended, if you will, in July of 2013 when the OCME released records, sent the index, et cetera, and nothing else happened regarding the public records case, other than pursuing the appeal here.
But I gather Judge Fishman tomorrow will be getting the entirety of the file, unredacted.
As far as I know.
All right. Is there?
I have asked the OCME, my client, whether they intend to comply, and they said yes. The order of the Superior Court was the subject of some single justice litigation recently in the county court, but once the DA's office got clarification of the Superior Court's order, it is my understanding that the single justice's case has been dropped, if you will.
And your understanding is that Judge Fishman will get the entirety of the file and will be reviewing it to determine what is material as part of discovery?
That's my understanding.
And
I have not been involved in it, but
Is there any part of the discovery that he has sought through the public records process that is not to be delivered tomorrow to Judge Fishman?
I don't know exactly the answer to that. All I can say, I would assume, because he has made his first-degree murder case so much a part of the public records case, I would assume that everything he's looking for in the public records case will be delivered to the judge in the criminal case, and there's no question that his rights to getting things in discovery is broader than his rights under the public records law. So I assume there is at least an overlap, if not, if not more, that he's requested. And clearly, his public records law request or is focused almost entirely on records regarding the particular medical examiner that did the autopsy in the criminal case.
All right. He used the term close contact autopsy. Do you know what that means?
I don't know what that means.
So if there are no further questions, what I will ask you to do is to furnish us with a 16L letter after tomorrow reporting on whether or not Judge Fishman indeed has received the documents and whether or not he has received all of the documents which were sought by Mr. Snell in his public records request, so that we can, the question which you understandably may not know now, you'll answer so that we will know that Judge Fishman will have in his hands all that he has sought through the public records process.
I can do
And
that,
that
Your
those
Honor.
were indeed delivered to Judge Fishman.
Yes.
There are no further questions? Thank you. Mr. Snell, thank you.
Thank you.